I would like to introduce our August webinar for the University of Kentucky's Office of Technology Commercialization, What You Need to Know to Stay in Compliance. Our presenter today is Sabrina Darnell. She is the Intellectual Property and Compliance Coordinator in the Office of Technology Commercialization. Sabrina, please take it over.
Thanks, Jackie, and for the introduction, and to everyone who has joined this informational webinar for the University of Kentucky units and researchers to be aware how to stay in compliance with our federal funding and the obligations we have under the Bayh-Dole Act. I wanted to start off with a little bit of know-how, places to go to find exactly the information of how you can stay compliant. These are very good resources. I use them quite often to make sure that we are doing the way things are supposed to be done. So I really, really recommend everyone to take these links, as I think Jackie's putting them in the chat for you to grab a hold of and post into your browsers as to favorites, especially the Bayh-Dole regulations and intellectual property policy and the timeline, because those are going to be the three areas that will help you the most with keeping your federal funding in compliance under these regulations. So without ado, we'll start getting ready and tell you what's needed. As a researcher, mostly your place is to make sure that you provide our office, the intellectual property, with a disclosure form, which is able to be found on our website. And you'll download that disclosure form. And then I'm just going to talk to the key areas of that disclosure form. There's many areas of that disclosure form, but Matt Upton has done a webinar, which I do believe is also on our website to help you with the other items that are on a disclosure form. But I'm just going to rely on the ones that are required to keep you in compliance with your federal grant. So the first thing is, when you submit your invention form to the Office Intellectual Property Office, it automatically gets signed a identifier number. We will also use this number to report with. It will be the UK IR number, and whatever number is assigned at that time. And then so it's important as an inventor that you kind of realize what those numbers are, because we use it to communicate with everybody that is the technology we're referring to. You need to make sure that you list inventors. The inventors, regardless if they are a university inventor or even if they're from an outside source inventor, because we'll still have to share when we report in iEdison for federal funding outside institutions also. So them are just as important, coming or going, that if you have one that you're working with on, they're taking the lead and they're doing the compliance for a grant, that they need to list you and list us on that disclosure also to federal reporting. The invention report date is also signed by the Intellectual Property Department. And it is signed the day that we receive it, and it's uploaded. So that's pretty basic. No need to really go any further in that detail. The grant numbers. The grant numbers, we need a list of all grants that are associated with the invention disclosure that you're submitting, and the organization, the sponsor of that grant. And it would be, I would recommend that the lead grant of the said invention is actually listed first, because they're going to ask which sponsor organization is the lead if there is multiple. So we'll need to make sure that I know when I do the reporting within iEdison who's actually the lead. So the invention title. So there's some confusion. What is an invention title? Well, the invention title should be brief but technically accurate and descriptive of the invention and should be less than 500 characters. I'm not even sure. I don't even think our system will take 500 characters, but as a rule, that's what they say the title should be. So, I mean, you know, really think about how you're wanting that title when you're providing it, because I mean, it is going to be required and it's going to be sent for the patent. You know, it could change once the patent's filed. I mean, you know, USPTO has their own decision what titles should be, but we report to them before then. So just kind of, you know, pay a little bit of attention and make sure you feel that that's kind of briefly describing your invention when you're selecting your title. Then within the description must be sufficiently complete in technical detail to convey a clear understanding to the extent knowing at the time of the disclosure, so that someone can read it and understand exactly what this disclosure is pertaining to. Also, we got to remember they will reject that report when I submit it if they feel this description is not sufficient enough and is not telling them enough information. And then that could delay our timing to getting the report done. So it's really important. I mean, like anything else, that, you know, these key areas of the disclosure regarding compliance is answered and accurate as best as you can. And then last but not least, you need to make sure you list all past and upcoming public disclosures pertaining to that invention. They are very crucial to the timeline. So we need to be aware of those publications. So just to kind of relay what I had just kind of talked about, the questions that you know that you really need to be asking yourself before you click that submit button. These are the key areas that could cause some trouble if they're not answered correctly, because, you know, whatever's in the disclosure is exactly what is submitted to the iEdison. So, you know, like I said, does your invention have sufficient description? You know, just make sure it's there. Are the main element of the invention listed? You know, if it's not there, they're going to reject it because they're not, you know, the element's not there. They just don't know what it's going to be about. And then if a lot of people, you know, reference attachments of, you know, designs or many things, or, you know, just don't want to type everything out and they have attachments. I mean, make sure all those attachments are attached when you're submitting, because those attachments also get reported along with your invention disclosure. And then once again, don't forget your, you know, any public disclosures that has happened. So let's spend a little time on the timeline that is required. This is really not, you know, something that the inventor themselves have to worry about, but it is something that intellectual property office does have to worry about, and we need your help to make sure that we hit these timelines. Because it can, if timelines aren't met, we're not in compliant. So that can cause you some trouble with your grant. So let's just kind of get familiar with what is on the timeline. So our office has 2 months after you have submitted your disclosure to report it in iEdison. So we spend some of this time making sure that all those things that I mentioned earlier that we get kind of worried about is, the description there is all the inventors listed. So we kind of spend that time making sure that we have all the information we need before we move forward with your disclosure. So, we have the commercialization team that gets signed your disclosure, they review it. Our intellectual property people that's reviewing it for your patent processes is reviewing it. So that's what all happens at that time. And then once they're good with it and they're saying we're moving forward, and I know exactly how to submit the disclosure, I submit it to iEdison. So, but we have a 2-month time frame from the date the disclosure was disclosed to us. So once it's disclosed, we have the next step would be to elect to retain the title of the invention. So we have 2 years after the disclosure of the invention to the agency, or 60 days prior to the end of any year stationary period, which is publication, on sale bar, public use, or that kind of stuff. So which will change it that we have 60 days if that has happened to elect and retain title. So then the next step is filing an initial patent application on the invention. We have 1 year of election of the title or prior to the end of any stationary period. And in district country or international patent offices within 10 months. So this is all of the filing of the disclosure. I mean, we can request extensions of time of disclosure, election, and so forth. And I haven't had or heard of them declining any of them as long as, you've requested it. So, we all just need to keep in mind, this timeline is a very tight timeline. So it's very important that we all keep our communication channels open via, our commercialization team. If they're reaching out, trying to talk to you about your invention, that you respond quickly to them so they can move forward. Or if it's the intellectual property department or our outside counsel is trying to find out information regarding patenting, that, as a researcher, that you respond in a timely manner to their questions so that we all can ensure that we stay within the timeline. I know, the best practice for all disclosures, but it's really crucial if you have federal funding associated with the disclosure. So, consequences of, failing to comply with VITAL. They do have consequences. You hear that they're going to come in and take your disclosure, sorry, or they ain't going to they're not going to file any more federal funding with you. I'm not saying those things won't happen, but I mean, as long as they feel we have tried, they are very, very willing to work with us. And they give us the opportunity to get in compliant with each one. You know, I mean, I'm going to use, like, for an instance, back when I first started, one of our inventors kind of got out of sorts with one of the agencies. Well, the agency reported us as being uncompliant. And they sent us an email telling us we had 60 days to get in compliant, or they were pulling all of our grants. And that's a scary email to get, but we worked with the agency, we got in compliant, and everything was fine. I mean, so it's not like, I mean, they're not wanting to take our technologies, but they're wanting us to be in compliant. So, I mean, lesson learned, don't kind of get nasty with the agencies. Just kind of be nice, and we all play the game and work along, get along, and everything will just move along really smoothly, and we'll get back in compliant and get them the information that they're actually looking for. Another situation that we had is one of our inventors had multiple grants with one technology. Well, no, actually it was 5 technologies. And then some of those grants were jointly owned with an outside institution. And then some of the grants we had the lead on, and some of the grants the other institution had the lead on. We had filed and was in compliant with the grants that we were the lead. However, the other institution had not reported the ones they were in the lead. So this is another reason why, you know, it's important that we know who the other sources are, so that we can get, you know, an IIA in place, so we know who's the lead and who's doing what and who to contact. And I mean, so luckily it's DOE. They worked with us, and it took a while to get the other institution to understand what they needed to do, because a lot of the institutions don't understand that you just type in our IADISON number on the disclosure, and it automatically shares the 2 institutions. But it's a learning curve for the ones doing the reporting, as much as the inventor learning what they need to provide for us to do the reporting. So, but we got it, and they were happy, and they got to do their final close, and everybody moved on to their next project. So, you know, like I said, it's a very open door, the compliance part is, and we just need to keep the communications open. So, retaining the rights of election and title is still, like all the things I keep saying, I know I sound like a broken record, and I just keep repeating, but these are such the crucial parts of being in compliant. And I mean, it's not a lot really, but it is a lot. So, you know, so as long as we're filing the disclosures on grants that actually have an invention associated with it. I mean, I'm not saying if it doesn't have an invention to file a disclosure, you know, we can just, when you do your closing statement, we just say there was no invention. So, but if it is an active grant and you are moving forward with it and actually have something to disclose, the invention disclosure needs to be filed when appropriate. Then as long as we're disclosing all the patents, and you know, that's all really done in-house in the intellectual property office. So we know we make sure that happens. The government support clause, that is done in-house. That is something that is responsible to go into the patent. So, I mean, when you file the invention and you start the patenting process, that's why it's important that you let us know at the beginning, because it's a lot easier to add it at the beginning than to go back in and try to amend a patent application because it needed a government support clause put in it. So as long as we're, doing the invention disclosures at the beginning and doing the patents, all the stuff just happens. Confirmatory license, it's automatic. Once the patent goes in, they automatically kick us back and we sign it saying, yes, this is it. And we sign it off and attach it in the system and we're good to go. Fine utilization reports, they're done yearly for each invention that we have filed and that is active. Most of them, it's just until a patent's issued or it's licensed or whatever, it's just that we tell them there's been no activity. But if it's been licensed, we need to let them know it's been licensed and how much income we received on it. So, that's like I said, it's not much, but it can get busy just depending on how active each disclosure is. So, to make a long story short, and me keep repeating myself, don't forget, we have to disclose within 60 days of us receiving the invention disclosure. Then we have to waive or elect title within 2 years of that. File patent within a year. Provide licenses to the government upon title election, which is the confirmatory license that I was mentioning earlier. File a patent and doing the utilization reports. And then at the end, when we're done, the OSPA team will get with us and do a final invention report. And as long as we have done all those above steps, the invention finalization report will be a breeze for everyone involved. So I know that's not much, and I felt like I just kept repeating and repeating, but as an inventor, that is your all's area to make sure you provide us with the detail, and we will make sure we file and follow the timeline for the reporting and to keep us in compliance, so that you will continue getting your funding and continue the awesome things y'all are developing for the university. So I guess at this point, if anyone has any questions or.
Thank you, Sabrina, for all that information on grant invention reporting compliance. Just a reminder, if you have questions, please put those in the chat button and we'll ask those. I do have a few questions for you, Sabrina. The first one is, what happens if the organization decides not to elect title on the invention?
So you mean if we decide not to actually pursue it, we have to actually get a waiver, if that's what you're referring to, from the iEdison group, which is actually the iEdison group is basically NIH. So it's the federal agency, because iEdison and all of the federal agencies are using iEdison. So they would have to review it to see if they actually want to keep it themselves. But we have to get it released from them to release it back to the inventors, let them do whatever they want to do with the invention at that point. But it's just not theirs because they had federal funding.
Thank you. We have another question. Any comment or advice about how faculty should or should not publish to preprint server websites with regard to the potential for IP, patents, disclosures, etc.
I mean, I think, I mean, I'm not sure if Matt's on here or not, and if he can unmute, he would be you would have to have it protected, and I'm not sure about that. That is actually his field of expertise. I personally would say until you disclose and you have it protected, that you do none of those, because it puts it at risk of not being patentable or able to be submitted for your grant without already being, oh, Matt came on. Matt, you want to answer that question
Yeah.
more better than what I just did?
So if you submit to a preprint server and it goes up immediately, essentially we need to have something on file at at least for patenting, we need to have something on file at the patent office before you do that. If you do that, you lose all rights to patent the invention in essentially 99% of the world. And it starts our 1-year clock running for patenting within the United States. So if you put it up on one of those servers and then tell us, 11 months later, odds are we're not going to be able to file on that, or we'll have to rush something in and it won't be as good as it could have been, and it can cause problems. So my advice is, before you do that, get it into our office, disclose it to us. We can take care of everything from the IP side and compliance side. And then as soon as we're filed, you can post that.
Thanks, Matt.
Thanks, Matt and Sabrina. Sabrina, we have another question. What is a government support clause?
Okay, the government support clause is just must be included in IEDISON and in the patents as a clause. There's a actual statement saying that that the government retains rights to it, so that anyone that is looking at the patent knows that it's just not the institution that owns this, but the government also owns it. So it's just something that support clause is added into the patent application when it's submitted to USPTO.
Great. And how can you request general waivers?
Well, general waivers, we have a couple of them out there that we're still waiting on. We have to, before we can expire a patent or anything, we have to reach out and ask if it has government funding associated with it that they don't want that. So it is done through our system, through IEDISON, and we have 120 days before the expiration of it not like continuing on from a provisional to a patent to get this waiver if it's a federal funding. So it's just a request from the federal agency stating, whatever reason. I mean, the inventor will provide us with the reason, or Matt will come up with a reason of why it's not feasible to actually file a patent. So yeah, it's very simple.
Great. Can you talk a little bit more about the utilization report, what it is, and who's responsible for it?
The utilization report is identifies the commercialization activities that's associated with the invention that has been reported for federal funding. I, as the compliance coordinator, is the one responsible for it, or whoever would be doing my position for the university. It is done once a year. We have like 60 or 90 days, I can't remember, to respond to that notifications. We get notifications of all of them that are active to provide a report back to iEdison. But that is our office's responsibility. And that's all tracked within our database.
Thank you. There's a question about whether other organizations like NSF have similar requirements like NIH does.
Pretty much all of them have the same requirements. There is a couple one-offs for some institutions, but for the most part, as long as we're all doing, I mean, we do that timeline in iEdison, we should be in compliance with most federal agencies. I think Air Force is maybe one that's one off, which we've not done a lot of grants with.
Great. And I have one more question, unless someone else has questions that they'd like to put in the chat. That question is, what if the NIH decides not to elect title? Can the inventor get the title?
If the University of Kentucky and in NIH or the federal agency has released the invention, yes, that can go back to the inventor, but not until we have a release from both parties.
Thank you, Sabrina. We don't have any other questions. Again, thank you. Thanks everyone for attending. We hope you will attend our future webinars. You can always find out about those through social media, our newsletter, or on our website. And if you have questions later that you think of, please feel free to email Sabrina at sabrina.darnell@uky.edu. And we will send out the link to this webinar to everyone who's registered, and it will also be on the UK Innovate YouTube page. Thank you and have a great day.